Good afternoon po sa lahat. I-report ko po ngayon yung continuation ng aming report, Section 28 to Section 32 ng Article 6 Legislative Department. Good afternoon po sa lahat. I-report ko po ngayon yung continuation ng aming report, Section 28 to Section 32 ng Article 6 Legislative Department. Ayon po sa paragraph 1 ng Section 28, the rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system of taxation. When we say taxation po, ito po ay isang proseso o pamamaraan na kung saan ang ating gobyerno sa pamamagitan ng kanyang legislative branch, the Congress and the Senate, ay nagpapataw ng tax sa mga tao, sa mga properties, privileges, and pati sa mga transactions within its jurisdiction para makalikom ng pera o ng revenue o ng pondo para syempre magampanan or matugunan nito yung mga legitimate objectives niya. So, binabanggit po dito sa Section 28 na dapat lamang na maging pantay-pantay at maging makatarungan ang tuntunin sa pagbubuwis. Ang kasaad dito na ang konsepto ng pagiging makatarungan sa pagbubuwis ay nakabase po sa kakayahan ng nagbabayad ng buwis na kayanin o pasanin ang buwis nito. And karaniwan pong sinusuko nito base sa laki ng yaman o ari-arian at kita o gross o net ng isang tao. Nabanggit dito yung the Congress shall evolve a progressive system of taxation. So dito, nangangahulugan po ito na ang batas sa pagbubuwis ay dapat na mas maglagay ng higit na diin sa direct taxes. Ito po yung income, donor, estate taxes. Sana siyang mas may kakayahan po na magbayad bilang pangunahing pamantayan sa indirect taxes o yung excise tax, VAT, and service tax. And this progressive tax system ensures that all taxpayers pay the same rates or the same levels of taxes sa bond income. And the overall effect po is that people with higher income pay higher taxes. Ang paragraph 2 naman po ng Section 28 ay tumutukoy po na sa pamamagitan po ng malinaw na provision na sa ligang batas, ang Kongreso ay maaaring magbigay sa Pangulo ng otoridad na magtakda ng mga rate ng taripa, import at export quotas, tonnage at wharfage dues at iba pang mga tungkulin o imposts. Gayun po man po, dahil po sa hindi pinapayagan ng ang Kongreso na isuko yung kanyang kakayahang gumawa ng mga batas tungkol sa mga nabanggit na paksa, ang otoridad po na pinagkaloob sa Pangulo ay nakapasailalim po sa mga limitasyon at paghihigpit na maaaring ipalagay ng Kongreso na angkop na ilapat. Kaya naman, dapat na gamitin lamang nito ng Pangulo yung otoridad niya sa loob lamang ng limitasyon ng National Development Program ng gobyerno. Binabanggit naman po dito sa paragraph 3 yung mga institutions and properties na exempted sa pagbubuwis, such as the charitable institutions, churches, personages, or convents appurtenances, mosques, non-profit cemeteries, and all lands, buildings, and improvements that directly and exclusively used for religious, charitable, and educational purposes. In paragraph 4 po, no law granting any tax exemption shall be passed without the concurrence of a majority of all the members of the Congress. Isinasaad lamang po dito na hanggat wala pong pagsang-ayon ng lahat ng mga nasa Kongreso, wala o hindi po maaaring mapatawan o mabigyan ng tax exemption ang isang institutions and yung mga properties. So, bago magpasa ng batas na nag-a-approve ng tax exemption, pagsang-ayon po muna ng lahat ang importante dito. Next po, Section 29, no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. Ang appropriation made by law po ay isang otorisasyon ng batas na ang pera ay maaaring bayaran mula sa kaban ng bayan. Ito po ang kapangyarihan ng Kongreso na gumastos na mula sa kaban ng bayan kung kinakailangan. Binabanggit po dito sa Section 29 na hindi po dapat gamitin o ipambayad ang salapi mula sa kabang yaman maliban kung ito po ay ayon sa laang gugulin na sa isinasagawa sa pamamagitan ng batas. ang kapangyarihang maglaan ng pampublikong pondo para sa pagpapanatili ng gobyerno at iba pang pampublikong pangangailangan ay isa pang mahalagang tungkulin ng pamahalaan na nakatalaga sa Kongreso. Ang Section 29 po ay nakabatay sa prinsipyo na ang pera ng mga tao ay maaaring gastusin lamang sa kanilang pagsang-ayon. And ang pagsang-ayon po na iyon ay maaaring ipahayag sa mismong konstitusyon o sa mga wastong aksyon ng Kongreso bilang direktang kinatawan ng mga tao. Also, binabanggit din po dito sa Section 29 na hindi dapat gamitin at imambayad ng anumang salapi, ari-ari ang pambayad sa tuwira at dituwiran para sa gamit, pakinabang o tangkilik sa anumang sambahan, sa institusyon o sa mga pari, pastor o ministro at iba pa. Maliban kung ang mga pari, pastor at ministro ay nakatalaga sa mga sandatahang lakas, pera institution, depresarium, or sa mga government orphanage. The Congress is also not allowed to appropriate public funds for religious purposes. For example po, the public funds must not be used to pay for the expenses arising from a birthday celebration of a Protestant pastor who have close ties with the politicians. The crime when you use the public fund for the other purpose aside from what the purpose for which it was intended is called technical malversation or illegal use of public funds. Next po, Section 30, no law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence. There are two jurisdictions involved in this section. First po is the original jurisdiction na kung saan ito po yung karapatan ng korte na dumilig ng kaso sa unang pagkakataon. And next one naman po ay ang appellate jurisdiction. Ito naman po ay ang kapangyarihan ng isang mas mataas na hukuman na dumilig ng mga apela mula sa isang mababang hukuman. So, this section po simply means na hindi po maaaring bawasan o kung hindi man ay alisin ng Kongreso ang original and appellate jurisdiction ng kataas-taas sa hukuman. Ngunit, maaaring dagdagan ng Kongreso ang jurisdiction nito sa pamamagitan ng pagtatalaga dito ng mga karagdagang kaso para sa mga paghatol. Next po, Section 31, no law granting a title of royalty or nobility shall be enacted. Ito naman po ay para mapanatili ang Republican and democratic nature ng ating bansa. Kaya naman dito sa section pong ito ay hindi po inaaprobahan ng Kongreso ang pagkakaroon ng batas na nagkakaloob ng titulo ng pagkahari o ng pagkamaharlikang isang tao o ng isang pamilya dito sa ating bansa. And lastly po, Section 32, ang saligang batas sa Section 32 po ay nag-institutionalize sa tinatawag na po ngayon internationally bilang People's Power na nagpapakita ng walang katulad na suporta ng mga tao sa panahon at pagkatapos ng 1986 presidential snap election at sa EDSA Revolution. So ito pong section na ito ay nag-uutos sa Kongreso sa lalong madaling panahon na magbigay ng sistema ng inisyatiba at referendum. Pag sinabi pong inisyatiba, ito po ay ang nakalaan na kapangyarihan ng mga tao na direktang magmungkahi at magpatibay ng mga batas sa mga botohan na tinatawag para sa layunin ng independyente ng Kongreso o ng isang lokal na legislatibong katawan. And ang referendum naman po ay ito po ang proseso kung saan ang anumang batas o bahagi nito na ipinasa ng Kongreso o ng isang lokal na legislatibong katawan ay isinumitin sa mga tao para sa kanilang pag-aproba o hindi pag-aproba. Ang kondisyon para sa paggamit ng mga nakalaan na kapangyarihang ito ay ang pagpaparehisto ng isang petisyon para doon na lagdaan ng hindi bababa sa 10% ng kabuuang bilang ng mga rehistradong botante kung saan ang bawat distritong pambatas ay kinakatawan ng hindi bababa sa 3% ng mga rehistradong botante sa nasabing distrito. Other details for its implementation are to be determined by law to be enacted by the Congress. And dito na po nagtatapos ang report ng Group 2. Salamat po sa pakikinig.
Okay, so Group 3 will follow immediately.
Sir, yung first reporter din po namin, recording din po.
Okay.
Of judicial power. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are meaning of judicial power. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. The judicial power rests within the Supreme Courts and the lower courts as established by the law, which can be found in Article 8, Section 1 of the 1987 Constitution. Its duty is to settle actual controversies involving rights that are legally demandable and enforceable. Also, the judicial power is the power to apply the laws to contests or disputes concerning legally recognized rights or duties between the states and private person which were properly brought before the judicial tribunals. Kumbaga po, kapangyarihan po ng korte na mag-decide sa mga cases na nag-i-involve sa rights ng mga tao. We are all free, pero we are still bounded by the laws. Therefore, we are protected by the law. Also, the power to determine whether or not there has been a grave abuse of discretion amounting to a lack or excess of jurisdiction. Dito po papasok yung korte para po malaman po nila kung meron po bang abuse sa kapangyarihan. Sila po yung magde-decide kung meron pong abuse na nangyari or wala po. Therefore, the sole part of the court is to review and to determine. Next is the scope of judicial power. So first is the adjudicatory power, and it includes the duty of courts of justice. So ito po yung mga trial courts. So this power will settle actual controversies involving rights which are legally demandable and enforceable. And for it to be legally demandable and enforceable in courts, rights must be derived from the law, meaning lahat ay dapat nakabase sa kung anong batas meron tayo. And for example, the rights of a wife to receive support from her husband. And then next is to determine whether there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So grave abuse of discretion means that such capricious and arbitrary exercise of judgment as is equivalent in the eyes of the law to lack of jurisdiction. And also, not even the President or Congress can be exempted by the judicial scrutiny. Next is the power of judicial review. And this power includes to pass upon the validity or constitutionality of the laws of the state and the acts of the other department of the governments, to interpret them, and to render binding judgment. So, ibig sabihin po, ito pong court na to, yung nagre-review po ng decisions from the trial courts. Basically, sila po yung tumatanggap ng mga appeals na binibigay po, and sila din po yung nagre-review ng mga cases. And last is the incendiary powers. This includes the incidental powers necessary to the effective discharge of the judicial functions, such as the power to punish persons adjudged in contempt. Sila po yung may kakayahan na magbigay ng parusa batay sa bigat ng pagkakasala ng isang tao sa batas. Next is, while giving of advisory opinions is not a judicial function. First is, it is the function of the executive officials. The judiciary is entrusted by the Constitution with the function of deciding actual cases and controversies. It cannot be required by the law to exercise any power or to perform any duty not connected to the administration of the judicial functions. Second is the doctrine of separation of powers. So this doctrine calls for the department being left alone to discharge their duties as they see fit. Like for example, the President and the Congress are not bound to seek the advice of the judiciary as to what they should do or not do. The judiciary is independent in itself within its power. And last is the pendency of many actual cases. With so many cases pending in courts, wherein there is an actual and antagonistic assertion between the parties, it would not serve the public interest at all if on hypothetical questions or matters, their time and attention would still have to be needed. Next is the judicial power vested in one Supreme Court and in lower courts. The judicial power under the Constitution is vested in one Supreme Court and in such lower courts as may be established by the law. So first is the classification of courts. Under the provision, only the Supreme Court is a constitutional court in the sense of being a creation of the Constitution. So all other courts are considered to be statutory courts, and this also includes the Sandigan Bayan, in a sense that they are creations of law. They are referred to as lower courts in the Constitution, meaning courts below that of the Supreme Court. Second is the creation and abolition of courts by Congress. Within their legislative power, Congress may abolish any or all lower courts and replace them with other court subjects to the limitation that the reorganization shall not undermine the security of tenure. It cannot also abolish the Supreme Court or add another Supreme Court. For what is written in the Constitution, there is only one Supreme Court. Neither can it abolish the Sandigan Bayan, although the Congress within its legislative power may determine its function and jurisdiction. Next is the organization of courts. So first, we have the regular courts, and the Philippine judicial system consists of a hierarchy of courts resembling a pyramid with the Supreme Court at the apex, under the Judiciary Organization Act of 1980. So the other courts are, first is the Court of Appeals, with 69 justices, headed by a presiding justice which operates in 23 divisions, each comprising 3 members. This court exercise administrative, ceremonial, or other non-adjudicatory functions. Second is Regional Trial Court, which is presided by 720 regional trial judges in each of the 13 regions of the country. And last is the Metropolitan Trial Court, and in each metropolitan area established by the law. Next is we have special courts. So aside from the regular courts, there are under present laws special courts. First is the Sandigan Bayan with 14 justices and a presiding justice, which operates in 5 divisions, each comprising 3 members, which was created by the Presidential Decree number 1606 pursuant to the mandate of the 1973 Constitution that it shall continue to function and exercise its jurisdiction as provided in said decree or as may be provided by a subsequent law. Next is the Court of Tax Appeal with 5 justices and the presiding justice, which was created under Republic Act number 1125 and was amended by RA number 9282, which has exclusive jurisdiction to review on appeal among other decisions of the Commissioner of Internal Revenue involving internal revenue taxes and decisions of the Commissioner of Customs involving custom duties. Then we have the Quasi-Judicial Agencies. These are the administrative bodies under the executive branch performing quasi-judicial functions like the National Labor Relations Commissions, the Employees Compensation Commissions, the Security and Exchange Commissions, etc. And the independent constitutional commissions do not form part of the integrated judicial system. So for the explanation ng mga courts, yung pinaka-highest court of the land is the Supreme Court. So sila po yung pinaka-huling magde-decide sa mga kaso. Kumbaga, dyan na po magtatapos yung case. Hindi na po sila, wala na po silang pwedeng puntahan pa. Kumbaga, yan na po yung pinaka-last na pwedeng mapuntahan ng kaso. Then next is yung MTC or the Municipal Trial Court. Mostly mga civil cases lang po yung mga nasa-settle dito. Mga cases na medyo mababa ng kaunti and na-violate ng batas against a person. Mostly yung mga ginagawa po dito is if both parties can amend or come up into a decision, then pwede na pong matapos yung kaso na yun. Pero kung hindi pa po, magpo-proceed na po siya sa ibang part ng courts or ibang other courts. Then next is the RTC or the Regional Trial Court. They can also be considered as a review court. And mostly mga criminal cases po yung mga naandito like mga paglabag ng mga batas against the state. So mga cases na dinadaan dito ay pwede pong iakyat sa Court of Appeals kaya pasok siya as a review court. And next is the Court of Appeals. Ang silbi niya po ay mag-review ng mga cases na galing sa ibaba. Appellate Court po siya. At kapag na-review na siya ng Court of Appeals, pwede na siyang iakyat sa Supreme Court at sa Supreme Court na po ang mag-handle at mag-decide ng kaso. Now, meron po tayong mga special courts which is yung mga side branches po and these are the Court of Appeals and the Sandigan Bayan. And then, meron din po tayong Sharia courts. Ito po yung mga courts para po sa mga Muslims dahil meron po sila mga certain rules but they are still subject to the law. Then, the Quasi-Judicial Agencies, sila po yung mga nagre-resolve ng mga disputes within particular organization. Ito po, pwede na din po silang mag-decide kung ano po yung conclusion ng case kahit hindi na po sila magpaano sa Supreme Court, kahit hindi na po sila dumaan sa Court of Appeals. Like for example, the NLRC, ito po yung mga court para po sa mga empleyado. Dito po yung mga labor cases mostly na nagaganap. Dito po sila pupunta kasi ito po mostly is, yun nga po, kung pwede naman pong makapag-amend or makapag-decide ang employer at employee, then they can both come up with the conclusion that can end the case. Next is the importance of the judiciary. So the courts perform a very crucial function in the society. So first is the confidence in the certain and even administration of justice. So nothing more clearly touches the welfare and security of the average citizen than his sense that he can rely on a certain and prompt administration of justice. Law is respected and supported when it is trusted as the shield of innocence and the impartial guardian of every private civil right. But if the law be dishonestly administered, the salt has lost its savor. If it be weakly or unfaithfully enforced, the guarantees of order fail. For it is more by the certainty than by the severity of punishment that offenses are repressed. So, ang ibig sabihin po is, kung hindi po kayang pagkatiwalaan ng mga citizen yung batas na meron tayo, hindi rin po madali para sa kanila na magtiwala o hindi kaya isumunod dahil nakita naman po nila kung paano po tinuturing yung batas sa isang bansa o sa bansa natin. Then next is the preservation of the government, where there is no judicial department to interpret and execute the law, to decide controversies and to enforce rights. The government must either perish by its own imbecility or the other departments of the government must usurp powers for the purpose of commanding obedience to the destruction of liberty. So kung wala pong judicial department, parang wala na din sense po yung government dahil ang nangyayari lang po is nagbibigay lamang po sila ng instruction sa citizen pero hindi po nila binibigyan ng kalayaan yung mga taong nasa citizen. Last is the respect for law and order. It is in the courts and not in the legislature that our citizens primarily feel the keen cutting edge of the law. If they have respect for the work of the courts, their respect for the law will survive. But if they lose their respect for the work of the courts, their respect for law and order will vanish with it to the great detriment of society. So, kumbaga kung nawala po yung respeto ng mga citizens sa ginagawang trabaho po ng korte, mawawala din po yung pagrespeto nila sa mga batas na meron tayo. At kung nakikita naman po nilang maayos po ang trabaho na ginagawa ng mga korte, like it is just and honest, mas lalong magbibigay po sila ng respeto sa mga batas na meron tayo. Next is, why is it necessary for a judiciary department to become independent? As in Section 2, Article 8, the Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. It states here that the Congress shall only advise and divide the work to the lower courts, but it shall not have anything to say to the decision of the Supreme Court over cases that the power of the Supreme Court holds. And the specific power will be discussed later on at Section 5. Kumbaga po, ang judiciary, kung hindi po siya magiging independent at susunod lamang sa dalawang branch, ay matatrample po yung justice system na meron tayo. Maapektuhan po yung justice system na meron tayo dahil susunod lamang po sila dun sa dalawang branch na kailangan nila. Kaya nga po meron po silang judicial power na yun po yung binigay sa kanila na makapagbigay ng decision regarding sa concerns or regarding sa disputes or controversies ng mga tao and even the state. Kaya importante po na maging independent sila in that aspect within their power.
Ayan, habang inaantay po yung next na presentation, clear po ba yung audio ko? Or... Hello?
Clear po.
Ayan, thank you. To conclude the Section 1, Article 8, sinasabi lang doon na yung the judicial power is the power to interpret laws and that only the judicial branch can decide whether a person or an organization is guilty nga or not guilty. And also, in relation with the last part of Section 1, Nakastate dito sa Section 2 that the Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts, but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. So it states here that yung Congress shall only advise and divide the work to the lower courts, pero hindi sila pwedeng magkaroon ng anything to say against the decision ng Supreme Court over cases na hawak ng Supreme Court. So yung specific powers na sinasabi dito is will be later on discussed nga on Section 5. Next slide po. Ayan, the power to apportion jurisdiction of various courts vested in Congress. So even though yung Congress can prescribe and do the apportion to the lower courts, of course, meron pa rin siyang limitations to exercise its power. So there are 3 limitations, including number 1, the Congress cannot diminish or otherwise impair the original and appellate jurisdiction of the Supreme Court over cases enumerated in Section 5 hereof, tulad ng sinabi kanina. So hindi sila pwedeng magkaroon ng anything na say against the decision or jurisdiction ng Supreme Court. Second limitation ng Congress, no law shall be passed reorganizing the judiciary when it intervenes security of tenure guaranteed in Section 11 na itatakal din later. And lastly, no law shall be passed increasing the appellate jurisdiction of the Supreme Court without its advice and concurrence. So tandaan nyo lang na if the Supreme Court says it, that should settle it. So next slide po. Ayan, meron tayong iba't ibang jurisdiction. So jurisdiction nga is the power and authority ng court to hear, try, and decide over a case. So narito yung mga example ng jurisdiction ng iba't ibang courts. So we have general jurisdiction states that when it is empowered to decide all disputes which may come before it except those assigned to other courts. So for example, yung jurisdiction ng RTC or yung Regional Trial Court. So remember sa sinabi ni Laika kanina sa presentation, RTC is a trial court but also a review court. So mostly criminal cases yung mga binabasa dito sa RTC, yung mga paglabag ng mga batas against the state, and yung mga cases na dinadaan dito is inaakyat pa sa Court of Appeals kung pwede. Next is yung limited jurisdiction. So when it has authority to hear and determine only a few specific court cases. So for example, is yung jurisdiction ng special courts. Again, i-define natin yung special courts tulad nung sinabi ni Laika kanina. Special courts have limited jurisdiction kasi they only serve for a particular population. So for example, nabanggit kanina is yung Sandigan Bayan. So yung Sandigan Bayan is a special court because nagdi-deal lang siya with instances of corruption involving a government official or an official government-owned body. So another example na binigay kanina ng special court is yung Court of Appeals. So yung Court of Appeals is in-exercise niya yung power and authority na hanggang appellate jurisdiction lamang. So wala silang original at exclusive jurisdiction over the Supreme Court. Another example ng special court is yung Sharia courts. So yung Sharia courts is yung korte na limited lamang sa cases na enumerated sa Code of Muslim Personal Law. So of course, the Constitution still has to recognize the principles of the Filipino Muslims. The next jurisdiction, we have the original, states that when it can try and decide a case presented for the first time. So mostly ito yung mga natatapos na agad sa lower courts like the Municipal Trial Courts and the RTC. Next, we have the appellate jurisdiction, states that when it can take a case already heard and decided by a lower court to remove from the latter by appeal. So ayun, self-explanation naman na siya, appellate, so tandaan nyo na lang yung word na appeal. So yung mga RTC and yung mga Court of Appeals. Next jurisdiction, we have the exclusive, states that when it can try and decide a case which cannot be presented before any other court. So itong exclusive jurisdiction means only a particular court can decide over a single case. So, for example, magpa-file ako ng case of bankruptcy. So, pag nag-file ako ng case of bankruptcy, ibibigay ko siya sa isang bankruptcy court. So ayun, may mga specific lang na cases na hinahandle ng isang court. So for example ngayon, yung bankruptcy court. So any other courts, like the state courts, have no jurisdiction over exclusive jurisdiction of specific courts. Next, we have the concurrent states that when any one of two or more courts may take cognizance of a case. So ito naman yung kapag two or more courts have different systems or different knowledge regarding a single case. So ito yung complete opposite na exclusive jurisdiction. So kung sa exclusive jurisdiction, isa at isa lang yung pwedeng mag-decide over a single case. Sa concurrent, pwedeng two or more courts yung mag-decide sa jurisdiction over a single case. So ito yung mga, for example, yung sa recent issue ng sa abortion sa Texas. Ayun, parang ganun yung example ng concurrent jurisdiction. And next, we have the criminal case as self-explanatory, which exists for the punishment of crime, and the civil jurisdiction, that which exists when the subject matter is not of a criminal nature. So ito yung mga nag-violate lang naman na cases against sa isang person or institution or nag-break lang ng contract. Ayun yung jurisdiction. Next slide. Ayan, before we proceed, meron bang questions? If none, okay, sige, proceed na tayo. Sa Section 3 naman of the Article 8, it states there that the judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year, and after approval shall be automatically and regularly released. So what is fiscal autonomy? It seeks to further ensure the independence of the judiciary. The appropriation for the judiciary may not be reduced as provided above, but they may be increased. So tulad ng nabanggit last meeting, a fiscal budget can only be increased but not be reduced. So it states here sa Section 3 ng Article 8 is that the judiciary branch shall only enjoy fiscal autonomy, and yung budget nga nila is pwedeng taasan pero hindi pwedeng bawasan. Yun lang yung point na ng Section 3. Next po. Ayan, next we have the Section 4 of the Article 8, which is the composition and sitting procedure. Gumawa na lang ako ng mini table para ma-differentiate nyo yung iba't ibang composition and sitting procedure ng iba't ibang courts. We have here the composition, age requirement, years of practice ng Supreme Court, COA, ng Regional Trial Court, and ng MTC or yung Municipal Trial Court. So sa Supreme Court, kinakompose ito ng 15 members, isang Chief Justice, and then 14 na Associate Justice. So yung number ng division nila is pwedeng iba-iba. So una, the number of divisions will be 5, composed of 3. So mahahati sila ng 5 grupo, and then may 3 member. Or pwede namang mahahati sila sa 3 division, pwede namang tagli-5 member. Or pwede naman na nahahati sila sa 2 division, tapos merong 8 and 7 members each. So iba-ibang division sila. Depende sa mapagkakasunduan. So the reason kung bakit sila dinidivide is para ma-avoid yung mga pending cases. Kasi alam naman natin na sobrang bagal nga ng process ng law dito sa Philippines. So to avoid those, hinahati sila sa iba't ibang division. And then yung sa Court of Appeals naman, yung composition niya, meron silang 70 members, isang presiding member at 69 na associate justice. So, nag-operate sila sa 23 na division at nahati yung 23 division na yun sa 3 members. And next naman, yung composition ng Regional Trial Court. So sa Regional Trial Court, tulad na nabanggit ni Laika kanina, mayroong 720 na Regional Trial Judges at nahati ito sa 13 na judicial regions. Lastly, we have the composition of the Metropolitan or Municipal Trial Court. So basically, isa lang naman per city or per municipality. Next is the age requirement For the Supreme Court, 40 years old dapat bago ka pumasok bilang judge, same as sa Court of Appeals. Well, yung sa RTC naman is 35 years old and yung sa MTC is 35 years old, and sa MTC is 30 years old. And then yung years of practice, both sa Supreme Court and sa Court of Appeals is 15 years, and then sa RTC is 10, and sa MTC is 5. So, makikita natin na sa years of practice pa lang, kaya mapapansin nyo na halos lahat ng mga judge sa Supreme Court or Court of Appeals is matatanda na kasi they have to prove muna yung loyalty nila sa law or sa Constitution. Next is, all must have proven competence, integrity, probity, and independence. And all must be a member of Philippine Bar and a natural-born Filipino citizen. Next slide po. Cases to be heard or decided and bank and vote required. So first, it states there that all cases involving the constitutionality of a treaty, international or executive agreement, or law shall always be heard and decided by the Supreme Court. To declare a treaty, international or executive agreement, or law unconstitutional, the concurrence of a majority of the members who actually took part in the deliberations in the issues in the case and voted thereon is required. So yung quorum sa Supreme Court, yung seating procedure doon is nahati sila sa 8. So yung majority na sinasabi dito is dapat 5 votes, pwede na silang mag-render ng isang decision over a case. And next, we have the all other cases, including those involving the constitutionality, application or operation of presidential decrees, proclamations, order, and etc., which under the rules of court are required to be heard and bank shall be decided with the concurrence also of the number provided above. So ayun, same idea lang naman doon sa number 1. Pinagkaiba lang is yung mga subjects tulad ng presidential decrees, proclamation orders, and etc. Next slide po. Ayan, so share ko lang din, paano ba natin malalaman na or paano ba dinedeclare ng Supreme Court na ang isang law is unconstitutional? Or ano bang gagawin ng President whenever na nag-declare na yung Supreme Court na ang batas nga na yun ay unconstitutional? So yung sagot doon last week sa tanong ni Sir is the President shall not implement the law anymore and dapat ipagsawalang bahala na siya ng Kongreso. Yun lang yun. And then we have here, in administrative cases where the decision is for the dismissal of a judge of a lower court, the same majority vote is necessary to order such dismissal. So again, ang majority vote is 5. So cases heard by a division shall be decided or resolved with the concurrence, likewise, of the same majority of the members who are at least 3 in number, but if such required is not obtained, then the case shall be decided. And the case modifying or reversing a doctrine or principle of law laid down by the court in a decision rendered en banc or in division shall be decided by the court. Next po. Yan, the meaning of executive agreement. So an executive agreement is an agreement entered into by the President on behalf of the Philippines with the government of another country and is effective of binding upon the Philippines even without the concurrence of Congress. So this is still debatable naman under the Article 7, Section 21. From the point of view of international law, wala kasing difference yung treaties tsaka yung mga executive agreements sa binding effect upon as long as the state is concerned. So, according nga dito sa classes of executive agreement, those who made purely as executive acts affecting external relations and independent of legislative authorization. So, ito yung they are used in the settlement of pecuniarily claims of citizens against foreign countries for violation ng rights na nagpo-protect sa kanila by treaties or basically sa rule ng international law. And then, second class of executive agreement is that those who entered into in pursuance of acts in Congress. So they affect, ito naman yung nag-a-affect sa internal affairs tsaka domestic rights. Kunwari yung mga tariff tsaka yung mga postal arrangement, yung mga visa, yung mga nilalakad na visa, trademarks and copyrights. Yun yung example ng executive agreement. Next po. The meaning of power of judicial review. So the power of the judicial review is the power of the courts, ultimately of the Supreme Court, to interpret the Constitution and to declare any legislative or executive act invalid because it is in conflict with the fundamental law. So it states there that the judiciary, the Supreme Court, enforces and upholds the rule of law and supremacy of the Constitution. So remember, the Constitution superiority. So bakit ginagamit ito? Because going back nga sa definition ng judiciary, ang korte lamang ang makakapag-interpret ng Constitution, pero hindi lang yung korte ha. Sila lang talaga yung nagbibigay ng decision or jurisdiction over different cases na nagsasabi na the study of our Constitution in large measure is the study of judicial decision and opinion on the meaning and application of its provision. So going back again sa Section 1, the power of judicial review includes the duty to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So nagkaroon ba ng abuse of power or not? Yun yung kina-question nila. So meron tayong tinatawag na question kung saan ito yung mga may political in character which ordinarily cannot be inquired into any other court. So, move on tayo sa next slide. Ayan, yung limitations ng exercise sa judicial review. So, may iba't ibang cases na nag-i-involve sa Constitution regarding sa pagpapasa ng treaty, law, presidential decree, and others. So, ito yung mga limitation. Number 1, there must be in concurrence of at least a majority of members who actually took part in deliberation on the issue in the case and voted thereon. So, again, dapat nasa majority yung members na nag-adhere or nag-concur sa case na yun or sa law na yun na ipapasa. So second, a law must be sustained unless clearly repugnant to the Constitution in view of the presumption of validity. So in other words, kapag mayroong dalawang possible na interpretation over doon sa law or mga issue na pinagdedebatean nila, yung isang interpretation is whether yung statute na yun is unconstitutional. And then yung isa namang interpretation is that that statute is valid and therefore can be constitutional. So ang kukunin ng Constitution, of course, is yung constitutional na decision, which is yung clear na pagdedebatean ng mga nakaupo sa korte. Next is the question of wisdom, propriety, or necessity of a law is not open to determination by the court. And of course, that the political questions are generally addressed to the political branches of the government. So, for example, ang political branch ng government is yung President at saka yung Congress. So, hindi yun sila pwedeng mag-justify ng isang political question. The Constitution naman, however, expressly confers upon the Supreme Court the power to declare a treaty unconstitutional despite the eminently political character. So ayun, hindi naman kasi talaga mawawala yung political characteristic sa iba't ibang law or presidential decree. So lahat yan sila is either may advantage sa isang political party or wala. So, it is the power of the Supreme Court to determine kung magkakaroon ba ng advantage yung isang political branch or hindi. So, dun din papasok si korte kung meron bang naganap na abuse sa power or wala. Next. Ayan, yung pinagkaiba ng justifiable question at saka ng political question. So, justifiable question is one which affects personal or property rights accorded to every member of the community in cases properly brought before the judicial tribunals, and also it is one which is proper to be examined or decided in courts of justice because its determination would not involve an encroachment upon legislative or executive power. So, ang justifiable question ay nagko-concern sa claim ng isang person against another. Tapos, yung political question naman states there that it is one which under the Constitution is to be decided by the people in their sovereign capacity or in regard to which full discretionary authority has been delegated to the legislative or executive branch of the government. Ang kinokonote naman ng political question is yung concern between a body politic and sa government ng state kung nagkaroon ba sila ng abuse grave in power or discretion nga. So, itong political question, madalas nung nagagamit noong martial law. So, madalas na mag-raise ng political question since part yun ng exclusive power ng executive branch. So, ang isang political question ay hindi basta-basta pwedeng erase at ipapadaan muna sa Supreme Court, of course, backed up by the law. So, the Supreme Court will then check whether magkakaroon ba ng abuse sa power, whether itatalaga ang martial law or not. Going back sa justifiable question, diniscuss ito ni Attorney Shell nung training sa PUP pre-law. Yung training kung if ever na i-raise sa'yo ang isang justifiable question. So, sinasabi ni Attorney Shell doon na the guilt or liability of one accused of violation of law, the powers of a government agency or office, the right of a citizen in relation to the government, and generally those involving the interpretation of laws or the Constitution are essentially within the competence of courts to pass upon. So, sinasabi niya lang doon na only the judicial branch can be assumed by a justifiable question. So whenever na i-raise sa'yo yung claim, kunwari nagkaroon ng issue regarding sa pag-atake sa'yo bilang PUP yan. So sinabi sa'yo na NPA ka and then in-arrest ka, warrantless arrest. So, pwede mong islap yung case sa kanila bilang personal yung take. So, yung personal na atake na yun, tinatawag yun na justifiable question kasi yung question na ni-raise sa'yo is kailangan mo munang i-prove whether or not NPA ka ba or hindi. Meron pa bong iba't ibang cases dito, pero hindi ko na siya masyadong i-elaborate. So, next slide na po. Ayan, yung section 5 naman.
Hello po, rinig po ako.
Yes po, rinig ko na.
Okay, thank you. So dito naman po tayo sa section 5. So yung beses na po siyang na-mention kanina. So basically ito yung section 5 po, may kinalaman po siya sa mga jurisdiction, mga kasong pwedeng hawakan ng Supreme Court. So yung una pong provision is the Supreme Court had the following powers to exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus, which we will define later. But let's discuss the first sentence of the provision. So, the Supreme Court has the jurisdiction over cases affecting ambassadors. Sure, sir.
What's the name of the last reporter?
Sa Avedra po yung last reporter. Ako po si
Avedra.
Celis po.
Yeah, okay. The question is for you. We've tackled already the power of the legislative to enact or make laws.
Nawala po ba si sir?
Yes po, nalaglag po siya.
Yes, nag-leave siya.
Do you hear me?
Yes, sir.
Yes po.
Okay, so before I proceed, so group 5, how many groups do we have?
Sir, group 3 pa lang po.
We have in the class.
6, sir.
Okay, so only group 4 have the assigned topics, isn't it?
Meron na rin po yung last 2, sir.
Meron na.
Yes po.
Okay, so up to group 6, they have assigned topics already.
Yes, sir. Meron na po.
Okay, so my question is with regard to the last reporter. We have studied already the legislative power of Congress to enact or make laws, and the executive power, on the other hand, to implement the laws. Now, the example is that the president refuses to sign the law which Congress passed following the legislative procedure of first, second, and third reading and publication. Meaning the bill now is for the signature of the president for it to become a law. But the president exercises the presidential power of veto, and so the president, in a written notice to the legislature, expresses his opposition by writing on the bill the reasons for not affixing his signature. It was returned to the legislature, and the Congress exercises the override power of the legislature. Okay, so that is the scenario. The president cannot anymore re-veto the bill because under our constitution, he cannot use the veto power for the second time. It can only be used only once. Okay? So therefore, the vetoed law becomes a law because Congress uses their override power. So the law was overridden by Congress. But still, the president refuses to implement the law that he vetoed once. Question. Congress now charged the president for not implementing the law. Is the law in question a political or justiciable issue? And if you are the president, what is your defense? I'm asking the last reporter.
Sir, I think magkakaroon po ng political question regarding sa hindi pag-enact ng president regarding doon sa law na pinasa ng Congress na in-override ng 2/3 vote. So therefore, pwede pong mag-file ang Congress na laban sa ginawa ng president na yun. So yung file ng yun is yung political question na po. So kailangan pong i-question whether or not magkakaroon po ba ng abuse sa political power or not, or dahil po ba hindi niya in-enact yung law kasi magkakaroon ng disadvantage sa isang political body or wala po.
So
it is a form of political question.
So you can compel the president to implement the law because that is a political issue.
Yes po, sir. And then, tsaka po siya papasok sa korte, yung political questioning.
What if the president says that you cannot compel me because I am an impeachable officer and I cannot be compelled because you can do so if you will impeach me?
Sir, I believe that the judiciary has the right, the Supreme Court has the right to exercise its power since ang mga branches naman po ng government, yung 3 branches ng government, is not competing but therefore co-equal branches. So they have equal authority and power over each other po.
Yes, but in the case, you cannot compel the president because he is an impeachable officer. So there could be a constitutional crisis in that scenario. So you analyze the situation first, no? In the finals, you will encounter those kind of questions. So you have to be prepared. Well, it may depend on your articulation on whether you are for or against the situation. Okay, I'm just testing your capacity to answer questions like that. Okay, so next reporter, you may proceed.
Alright, thank you po, sir. Again, ako po si Ceres po, first name ko po Proceso. So yun po ang ito is section 5, which is all about the jurisdiction ng mga kasong pwedeng hawakan ng Supreme Court So una po, ang unang provision po is the Supreme Court can exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus, which we will define later po. But yeah, so sabi po dito, yung Supreme Court, meron siya yung mahawak sa mga kasong may kinalaman sa mga ambassadors, sa mga public ministers, sa mga diplomatic agents, and ang nire-refer po ng Constitution when it says ambassadors or public ministers and consuls ay yung mga ambassadors po na accredited dito sa Pilipinas. So, ibig sabihin po, mga diplomatic officers na galing sa ibang bansa, mas dito sila accredited sa Pilipinas. So, pag may kasong may kinalaman sa kanila, ang Supreme Court po ang merong jurisdiction over that. Although, as I presume every one of us already know na meron pong certain level of immunity ng mga ambassadors, mga diplomatic agents and consuls when they are here. So, when accredited sila sa isang bansa. So, the diplomatic convention provides them an immunity towards immunity over civil, administrative, and criminal jurisdiction. However, sa Constitution po, it explicitly states that unlike the ambassadors and public ministers, consuls do not enjoy the same privilege as the ambassadors and public ministers. So when it comes to criminal jurisdiction, pwede po sila maging liable. And again, yun nga po pag mga ganong kaso, hawak po siya ng Supreme Court. Next slide, please. Second provision po, the Supreme Court can review, revise, reverse, modify, or affirm on appeal or certiorari as the law or the rules of the court may provide, final judgment and orders of lower courts in. So ito na po yung mga kaso na pwedeng hawakan ng Supreme Court. So una po is yung cases in which the constitutionality or validity, as what was mentioned earlier, validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. So basically, yung legality or yung itong mga klase ng batas na ito or treaty, if they are in conflict with the Constitution or if the legality is in question, hawak po siya ng jurisdiction po ay nasa Supreme Court. Next is all cases involving the legality of any tax, imposed, assessment, or bill, or any penalty imposed in relation thereto. So again, legality of any taxes or fees na isinabatas. So hawak din po siya ng Supreme Court. All cases in which the jurisdiction of any lower court is an issue. So if a lower court acted beyond or in excess of its jurisdiction or should be acting upon cases within its jurisdiction, if that is in question, hawak po siya ng Supreme Court. All criminal cases in which the penalty imposed is reclusion perpetua or higher, hawak po yan ng Supreme Court. And then lastly, all cases in which only an error or question of law is involved. So mamaya po mag-define natin yung sabihin ng question of law. But basically, when we say question of law, it's about how the law applies in a particular case. Next slide po. Yeah, so yun nga ba, the Supreme Court exercises original jurisdiction over petitions for the issuance of writs of certiorari, prohibition, and mandamus against the Court of Appeals. So ito po yung mga definitions. So pag sinabi po natin certiorari, ibig sabihin lang po yan, it's when a higher court, which is in this case the Supreme Court, orders a lower court to transfer a case or the details of a case for review. Just if the situation, the lower court acted in excess or beyond its jurisdiction, and if there are no other remedies for the particular case. So, example po nito is yung petition that seeks to disqualify the certificate of candidacy of President Marcos. So, nung dinesisyonan po siya, nung binasura po siya ng Common End Act, yung mga petitioner po, nag-request sila for certiorari or writ of certiorari. in which they desire that the Supreme Court, which is the higher court, request the COMELEC NPAC, which is a lower court, to transmit this case para po i-review ng Supreme Court. So yun po example ng certiorari. It's a higher court requesting for a case from a lower court, which is up for review. Prohibition naman po, it's a writ by which a superior court orders a lower court or board or person acting with or beyond the jurisdiction to be ceased from further proceedings. So pinag-aiba naman po ng prohibition, it's a higher court ordering a lower court to cease from any proceedings or pagdinig sa kahit na sa isang kaso, especially or specifically kapag yung kaso po yun ay beyond, labas na sa jurisdiction ng lower court or wala nang iba pang remedy to resolve that particular case. So kapag pinahinto na po ng higher court ang proceeding is ng lower court, that is because of prohibition. Mantamos naman po, it's an order issued by a superior court ordering a lower court to perform a certain act which is its duty to do so. So it's kind of like the opposite of prohibition. Dito naman po yung higher court, dinedemand niya po na yung lower court na mag-conduct ng proceedings sa isang kaso na nasa jurisdiction naman niya. And then lastly, pag sinabi po natin co-warrant to, ito po ay yung paraan ng gobyerno para ma-recover or makuha ang isang office or isang departamento o kahit ang isang franchise na hinahawakan ng isang opisyal o ng isang korporasyon unlawfully or illegal nilang hinahawakan. So kapag gusto magpatanggal ng isang petitioner ng isang opisyal sa kanyang pwesto, co-warrant to po yung tawag na at hawak po yung Supreme Court. Next slide po. So, the exclusive appellate jurisdiction of the Supreme Court, so na-define na po siya kanina you guys can remember, pag sinabi mo natin appellate jurisdiction, it's when a court has the jurisdiction to hear cases na nadinig na sa mas mababang korte. So, yung Supreme Court po, since pwede siyang mag-review, mag-modify, mag-affirm ng mga kaso na nasa ng lower court, so ang ibig sabihin po na nagano siyang appellate jurisdiction. So, the exclusive appellate jurisdiction of the Supreme Court refers to the cases of great public interest or of serious moment to individual rights. So, kapag ang isang kaso po ay may kinalaman na sa batas na tumutukoy sa karapatan ng isang mamamayan at kapag malaking issue po siya, pwede po siyang kunin o dinggin ng Supreme Court kasi nga may appellate jurisdiction po siya. And meron pong dalawang paraan yun. Una is by appeal. So it's the appellate court reviews all the findings of law and of fact of a lower court as in special proceedings. And then by certiorari, the appellate superior court can review only questions of errors of law or committed by a lower court. So pag sinabi mo kasing question of law, ibig sabihin lang po nun, paano nag-a-apply yung batas natin sa kaso na to. Tama ba yung pagkaka-apply ng batas sa kaso or it's a question of legality basically. Tapos yung question of fact naman po, may kinalaman lang po siya sa kung nangyari po ba talaga yung ina-assert ng decision ng isang korte. Kumbaga, truthfulness ng decision, kumbaga, o ng kaso na dinidinig. So kapag by appeal po, yung paraan ng pag-file ng kaso sa Supreme Court, may kakayahan po yung Supreme Court na questionin hindi lang yung legality or kung paano nag-a-apply yung batas sa kaso, may karapatan din po siyang reviewin, kumbaga, yung truthfulness o yung question of fact ng isang kaso. Pag by certiorari lang naman po, ibig sabihin yung kasong nadinig ng lower court ay ipinasa sa Supreme Court, ang kaya lang po questionin or i-review ng Supreme Court ay yung question of law. Kasi sabi po sa Constitution, in theory, mas may kakayahan or mas may kakayahan ang lower court na dinggin o na questionin ang katotohanan ng isang kaso kasi nakikita ng lower court yung demeanor ng mga witnesses, nagkakaroon sila ng first-hand experience sa mga involved sa kaso. So, pag ganun po, question of fact yan. Kapag by certiorari, ang pwede lang po questionin ng Supreme Court is kung paano nag-a-apply yung batas doon sa naging desisyon ng lower court. Next slide po. So, next provision po, the Supreme Court can assign temporarily judges of lower courts to other stations as public interest may require. Such temporary assignment shall not exceed 6 months without the consent of the judge concerned. Now, contrary to the 1935 Constitution, basically ang purpose po kasi nito itong kapangyarihan ng Supreme Court para mas ma-enhance yung kakayahan ng Supreme Court na kontrolin ng Judiciary Department and para maiwasan na rin yung political influence kasi dati daw po dati po sa 1935 Constitution may kakayahan po ang Executive Department na mag-transfer ng mga judge from one regional court to the other. So to enhance the power of the Supreme Court over the Judiciary Department, pinilipat po yung kapangyarihan na yun papunta sa Supreme Court dito sa 1987 Constitution. And a consent must be given by the judge if they are to be assigned either more than 6 months or permanently. So, kapag po yung assignment ng isang isang judge sa isang regional court more than 6 months or if it's permanent, kinakailangan po siya ng consent ng judge in question. Pero kapag 6 months lang naman po or temporary lang, kayang-kaya po ng Supreme Court na mag-assign ng mga judges sa mga regional courts or lower courts. Next slide, please. So, the Supreme Court can order a change of venue or place of trial to avoid a miscarriage of justice. This is mainly for the pursuit of fair and impartial trial. The Supreme Court can order a change of venue or of place of trial. So, kapag yung korte po kung anumang, o specifically yung lugar po saan ginagawa yung pagdinig, kapag nakaka-apekto po siya sa pagiging impartial o fair ng pagdinig ng kaso, may kakayahan po sa Supreme Court na baguhin yung venue to make sure that maayos po yung nagiging pagdinig ng kaso. Next po. So, next provision, the Supreme Court can promulgate rules concerning the protection of and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the unprivileged. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. So this basically just means na ang Supreme Court po pwede po siya magbaba ng mga rulings na pwedeng maging patas or na may kinalaman sa pagpapatupad o may kinalaman sa karapatan ng isang mamamayan Pilipino, kakayahan niyang magsampa ng kaso, and also the law as a profession and as a practice. So may kinalaman po doon, pero po kakayahan ng Supreme Court na gumawa o lumikha ng batas para protection ng mga ganang bagay. And lastly nga po, mag-provide ng legal assistance sa mga underprivileged. Next slide, please. So, the Supreme Court can promulgate rules relating to the protection and enforcement of constitutional rights. So, the Supreme Court has the power to promulgate rules to ensure that the people can enjoy the constitutional right. This power aims to protect and enforce these rights. Furthermore, this is to prevent the equal application of the law, which is usually at the cost of the poor and helpless ignorance. So, yun nga po, pag may kinalaman yung Supreme Court po, kaya na maglabas ng ruling na ang aim o ang purpose is to protect the rights of its citizen, and especially kapag sa mga sitwasyon na yung pagkakat ng batas ay nasa at the cost of the poor. So to make sure that the Constitution, our rights is exercisable, the Supreme Court can issue rulings that will further enhance those privileges. So pleading is simply the act of presenting one's claim, answer, or argument in defense or prosecution of an action. So, ibig sabihin po ng pleading yung pagkapagsampa ng kaso and at the same time pag-respond sa mga kaso na isinagpalaban sa ikaw man yung sinagpa ng kaso. the exact opposite reading is also the way of exercising your right kapag ikaw na yung agreed party. Practice of law, the doing or performing of service in a court of justice. It includes legal advice or preparation of legal instrument, among others. So basically, yung trabaho ko na pagiging isang lawyer. Procedure, methods by which substantive rights may be enforced in the courts of justice. Next slide po. So the bar refers to the collectivity of all persons whose names appear in the roll of attorneys of the Supreme Court. So actually, accessible po ito sa website ng Supreme Court. So it's literally just a list of all the members of the roll of attorneys of the Supreme Court, basically mga lawyers sa Pilipinas. So pwede po kayo mag-search ng mga pangalan doon. So lahat po ng naka-include doon. Ang tawag po doon ay bar. So lahat po ng naka-include doon kay mga tao, parte ng bar o mga attorneys sa Pilipinas. Admission to the practice of law or to the bar, which is a person is admitted or becomes a member of the bar, possesses, if that particular person possesses the requirements such as legal, moral, or educational qualification, which is to be decided by the Supreme Court. Integrated bar, the official national unification of the entire lawyer population of the Philippines in a single organization. And lastly, legal assistance to the unprivileged, the Supreme Court ensures or wants to ensure that the poor and the uninformed litigants can defend and enforce their rights through free legal assistance, which could include lawyers and waiving of court fees. So, ito po sa pagpoprotekta ng karapatan ng mga tao o ng mga Pilipino, nais din po ng Supreme Court na bigyang kakayahan ang mga underprivileged o yung mga walang kakayahan na paglaban ng kanilang karapatan kapag ito ay naging dehado. So they can do that by providing legal assistance, which includes lawyers o pag-waive ng mga court fees kapag nagsasampa po na kaso o may kaso binibili. Next slide po. So, meron din po mga limitasyon. Of course, yung rulemaking power, yung kakayahan ng Supreme Court na gumawa ng mga rulings. So dapat po such rules shall provide a simplified and expensive procedure for the speedy disposition of cases. So self-explanatory, dapat po yung mga rulings ay madaling i-implement at madaling intindihin para po mapabilis yung pag-a-apply ng batas na yun. They shall be uniform for all courts of the same grade. So dapat po pantay yung pagkaka-apply ng batas na yun kahit sa ang korte ka man pumunta. And they shall not diminish, increase, or modify substantive rights as distinguished from procedural rights. So ito po mga ruling na binababa ng Supreme Court ay dapat hindi na mababawasan, may enhance, or mababago yung mga karapatang ibinibigay sa atin ng Constitution. Next po, please. So just for definition po, substantive law is a part of law which creates, defines, and regulates rights over life, liberty, property, or power. It is facilitated by the adjective or range of law which prescribe methods of enforcement of such rights. Substantive rights, on the other hand, are rights which substantive law declares are right concerning life, liberty, and property. Procedural rights are waived which an agreed party whose rights have been violated to appeal. So, ang substantive law po yung nag-create ng substantive rights. And to implement this substantive law, we utilize what we call the adjective or remedial law. At kapag yung substantive rights po natin na-violate, meron po tayong procedural rights which yung pag-i-plead or pag-a-appeal sa mga korte ng Pilipinas. So, panibagong provision po, next provision, the Supreme Court can appoint all officials and employees of the Judiciary in accordance with the Civil Service Law. So yun nga po, self-explanatory, pagdating po sa pag-appoint po sa pag-a-assign ng mga judges sa mga regional courts, mga empleyado po ng Judiciary Department, it's under the provision, under the jurisdiction of the Supreme Court, which in accordance with the Civil Service Law. Next slide po. na lang po yung last provisions. Thank you po.
Hello, sir. Ako po yung magre-report for Section 6. Pero, sir, may klase na po kasi kami. Okay lang po ba sa Saturday na lang po ituloy? Last 3 reporters po from our group. Sir, nakamute ka po. Hello, sir. Nakamute ka po.
Okay, Abuan.
Present po.
Ancot. Ancot. Baserdo. Baserdo. Bajar. Bajar. Baluyot. Baluyot.
Yes po, sir.
I'm checking the attendance.
Na-check ko na po, sir.
What? Alin ang na-check?
Sir, habang po ongoing po yung class, nag-check po ako ng attendance. We'll send po later po.
No, I'm checking now. Basco.
Present po, sir.
Batong.
Sir, nandito po si Batong. Mahina lang daw po yung signal sa kanila ngayon. Present po siya.
Cabradilla.
Present po.
Calleja. Calleja. Correspondence. Okay, Canindo. Okay,
Present po, sir.
Celis.
Present po, sir.
Sid. Sid. Ampi, Sid. Kopian.
Present po.
Endona. Endona. Espinola. Espinola. Evangelista. Evangelista. Fetalvero.
Present po, Telvero.
Gaton. Gaton. Javier.
Present po.
La Rosa. La Rosa. Mercado. Mercado. Nagrampa. Nagrampa. Nieva.
Present po.
Oferina. Oferina. Otesa. Otesa. Alapus.
Present po, Palapus.
Perez. Chana Perez. O.
Present po.
Saavedra.
Saavedra po, present.
Salonga. Salonga. Sibug. Sibug. Silvestre. Silvestre. Si. Si. Taoy.
Present po, sir. Nandito din po si Salonga saka po si Gaton. Thank you po.
Salonga and
Salonga and Gaton po. Baka po mahina lang po yung signal na ulan po kasi, sir. Pero nandito po sila. Nag-report po kanina si Malu Gaton. Thank you po.
Okay. Victohay.
Victohay, present po.
Okay.
Sir, hindi po natawag sa Pelagyaw. Present po.
What's the name again?
Pelagyaw po ni Paul.
Palagyaw. Okay, Nicole. Who was not called? So I repeat the attendance, second roll call. Ancot, Baserdo, Bahar, Calleja, Endona, Espinola, Evangelista, La Rosa, Teoferina, Pancho, correspondence, Perez, Po, Saavedra,
Sir, nandito po si Po. Si Janelle po.
Sa Avegra din po.
yeah, okay. Sibug, Silvestre, and C. Okay, who was not called? Okay, so
Sir, kanina po nandito si Evangelista pati si Silvestre. May inasikaso lang daw po.
who's the other one? Silvestre and?
Evangelista po. Evangelista.
Okay, so no more question? Okay, there being no more questions, so the class is dismissed. See you next meeting.